For Mr. Mayers, Joseph Tacopina, along with Sarah Kaplan.
Paul Prislomic and John Lewin for the people.
Just so it's clear, Your Honor, I'll be joining as the second lawyer on the case for the District Attorney's Office.
Okay, that's perfectly fine with me. We've had some discussions off the record that I want to put on the record. I understand that there is a settlement is not out of the question, but there has to be some discussions between both sides. But it is more likely than not there won't be a settlement, but it's possible. Is that correct?
Your Honor, from our side, we have no interest in a settlement. Our client does not indicate he's willing to take anything, but obviously I will listen to anything, any offer, and I have an obligation and a duty to relay it to my client, which I will do.
All right.
And I think just so it's clear, Your Honor, what we wanted to do, given that the defendant, if he's convicted, even at midterm, is looking at years in state prison with at 2/3 time, we wanted to make sure that before he ends up going to trial, that he understands what we would be asking.
Well, I'll do that on the record when on Tuesday.
Right, I just wanted to clarify counsel's comments. So we, in response, indicated that, okay, if it's worth us checking to see what an offer would be on this case, we'll do it. Counsel indicated that it is definitely worth doing that because his client needs to be made fully aware of what his options are, and that's what we're doing.
All right. We're going to have to do the case in Department 102. What I would like you all to do, though, on Tuesday, which is the 21st, to come here first to this courtroom. If you could be here at 10 o'clock, we'll have a jury panel. Is it 10:40? It has to be 10:45?
The jury sitting
10:45 out in the hallway in front of Department 102. We're going to tell the jury that it's going to take approximately 15 court days. Does everybody agree with
Yes,
that?
Your Honor. Yes.
All right. As far as jury selection is concerned, I will discuss I will let the jurors know that regardless of who a defendant is, whether they're the richest person in the world or the poorest person, everybody is to be treated the same. Nobody is to be given brownie points or lose brownie points. I'm just using the word brownie points just as an illustration because of their status in life. Everybody has to be treated the same. If the evidence proves a defendant guilty beyond a reasonable doubt, I'm going to tell the jury, your job is to vote guilty. If the evidence doesn't prove guilt beyond a reasonable doubt, your job is to vote not guilty. And I'm going to discuss with the jurors the various levels of proof, preponderance, clear and convincing evidence, and proof beyond a reasonable doubt. I will also talk about the fact that the charges are not evidence. I'll talk about the burden of proof. I'll talk about the presumption of innocence. I will ask the jurors whether they or anyone close to them have either been accused of or been the victim of a crime of violence. I'll ask them if they are aware of or do they know either the defendant or who his is it his girlfriend?
His wife. It's his common law wife, Your Honor. They have two children together, so
right. So I should characterize it as common law wife?
Or just wife. It's fine. However you like, but yes, they're
No,
not. I mean, they're common law husband and wife.
I'll call
Together.
her whatever you want me to call her. You want wife? Okay.
Sure.
Your Honor, I think if they're not legally married, we prefer that she not be referred to as his wife and that she is just referred to as his significant other or mother of his children.
Are they legally married anywhere?
I don't know, but
Right.
certainly they're common law husband and wife.
If they're legally married anywhere,
Yeah.
There's no common law marriage that's recognized in
Just
California.
call what you want, I don't, whatever. It's okay.
If they are legally married anywhere, she will be his wife.
Okay.
If they are not legally married anywhere, she is his
Significant other, okay.
All right.
Thank you, Your Honor.
I will also consider asking, go into additional areas with the jury, the prospective jurors, upon hearing input from both of you, if you can think of areas you want me to go into. Once I'm finished, both sides will have a very good idea of what's in the jury box. I'll only talk to 12 jurors initially. Each of you will have an hour to talk to the original 12, and then each time the juror is excused and replaced with a juror, you'll have 5 minutes with that one juror. Our jury trial hours will be 10:30 to noon and 1:30 to 4 o'clock. You're welcome to have any non-alcoholic beverages on council table if you want to. If during the trial you feel the need to approach a witness to show them an exhibit, or for some other reason you feel the need to approach the witness stand, you don't need to ask permission, just do it. Because 99.5% of the time the answer would be yes, that you can, so I don't see the need, of the formality of, that you have to ask permission. If a witness needs to refresh their recollection with some type of a document, you don't have to ask permission whether it's okay. It will always be okay. So just let them refresh their recollection with whatever document it is. Regarding what we talked about, discovery, I understand the people have fully complied with Penal Code Section 1054. What I have directed the defense to do is their witness list consists of, what's the total number of people on your witness list? 30?
I think it's 34 years, I'm sorry. It's 34 years.
You mentioned that it's your intention to not call many of them, but
Yes.
what I directed you to do is for those witnesses you know you're going to call, or you reasonably know you're going to call, that you are to provide complete discovery, any written statements, recorded statements, any statements of any kind to the prosecution. For those witnesses that you're not sure of, I want you just to provide a paragraph summarizing what they would say if they did take the stand.
Sure.
Although the witnesses were not named, the court had indicated when counsel said there were two
Yes.
witnesses, that those two witnesses are to be provided the full discovery now.
Wait, has that been provided yet or not?
No, it is not,
Well,
but it is to be
They have,
provided.
but we'll get to them, but they do have.
Can you do that in the next 24 hours,
Sure.
provide them full discovery of the people that you know you're going to call?
Yes.
Thank you.
All right.
Your Honor, speaking of which, apparently, now I'm communicating with my office in New York, Mr. Siegel's been in touch with Paul, and apparently there are two witnesses on their list, apparently that we don't have any discovery from, and there's been no summary of what their testimony will be, either Vivian Gonzalez and Patrick Marr.
That's not true.
Vivian Gonzalez and
true.
Patrick who?
Marr,
Spell it.
M-A-R.
They are both employees of the Orange County Regional Computer Forensics Labs. They are the technicians that imaged or duplicated the defendant's cell phone. So the defense has been provided a full Cellebrite copy of the defendant's cell phone and the reports associated with that extraction, which is where what they did and their statements are contained, was also provided to the defense.
Do you have-
So Vivian's and Patrick's statements were provided?
Yes, their reports
Provided to who?
to the defense.
Okay.
To Mr. Tacopina?
Yes, they're his
All of
office,
us,
him, Miss Kaplan.
Did you
yes.
do it, Mr. Prisloman?
I would have to look at the discovery receipts. I know it's been turned over to them, but that may have been provided by Mr. Engel prior to my involvement in the case.
All right, I'm going to assume that it has been turned over. If for some reason you don't have it after a due diligence search, then we'll revisit it.
Okay.
One question regarding objections. Some of the courts do it two different ways when we have multiple lawyers. One way.
Thank you for bringing that up, and I was going to. It's one lawyer per witness.
And the question I would have, Your Honor, is in terms of objections, can it be designated, and it will be designated in advance? As an example, let's say that I am questioning a witness on direct, but that my co-counsel is going to handle the objections. In other words, my understanding is, unless the court controls.
No, why does it have to be that way?
Well, depending on what the witness is going to be, we might tactically decide that the non-questioning lawyer is in a better position to be handling objections, either tactically, maybe in terms of overall comfort with the evidence code, et cetera. So I think the issue is that you have more than one person speaking. We would designate in advance that X lawyer is going to be handling objections on this witness.
All right, that's agreeable, but it's going to apply to both sides.
Yeah, thank you.
But it's only one lawyer who's doing the objecting.
Yes,
So if you're doing the questioning, Mr. Przlomiak is doing the objecting, he's the one that's going to be doing the objecting, no objecting by you.
yes.
And same thing with the defense. Only one lawyer can lodge objections.
I've never heard that before.
Well, that's the way it's going to be here.
Okay, whatever you want to do is fine.
So if there's a witness on the stand, and decide amongst you who is going to be handling that witness, that lawyer will be the only one lodging objections. There's not going to be any team objecting.
Well, but based on what I just heard, it could be one lawyer doing the questioning and a different lawyer doing the objecting.
Correct.
Okay.
And when you call a witness, if you want to do the questioning of the witness, but you want Ms. Kaplan to do the objecting, Ms. Kaplan will do the objecting, but not you.
Or conversely, if I'm cross-examining the witness and I want Ms. Kaplan to do the objections, we can do that as well.
That's fine, yes.
I mean, I don't see that unfolding that way, but okay, thank you.
There's not going to be multiple lawyers objecting to the same witness.
No, I understand.
All right, what else? Oh, on any issue that comes up, any ruling, any decision, I'm going to listen to both sides, and then I'm going to make a ruling. Once I make the ruling, that's the end of the issue. I don't want to hear from either side, oh, can I be heard? Can I make a record? Can I supplement the record? Once I make the decision, that's the end of the issue. And then we move on. There's not going to be any belaboring.
Understood, Your Honor. We would also request that, I think all counts are going to understand, if there is an area of questioning that in any way, I'll give an example, counsel thinks that the door has been opened with a certain witness. Any question that's going to be asked by either side, where there's any legitimate issue of the court needing to make a determination on relevance, 322, et cetera, we want to ask to approach.
Sidebar.
So our position is we can assure the court that if something is close and we haven't litigated it, we'll ask to approach. We can only ask the same
And
on the other side.
the sidebar, we do right here. That's, Mr. Tacopina, there's a remote there. It's connected to Kathy. She puts on a headset, and she'll hear what everybody says.
For sure.
Should add, Your Honor, I'm going to be probably using, I have 2 hearing aids, unfortunately, and I don't hear very well. So during jury selection, I tend to use, it looks like a headphone, but what it is it magnifies the sound so I can hear. So I'm not listening to whatever else is out there, but that'll be on my head during selection.
A$AP Rocky has a new album coming out, if you want.
Oh, so I know, I'm going to introduce you as Paul Przlomiak, John Lewin. Do you want to be Joseph Tacopina or Joe?
I think Joe's fine, Joe.
All right, Sarah Kaplan, and who's the other?
Chad Siegel.
Chad, C-H-A-D?
Yes, C-H-A-D.
Chad.
Siegel. And then there's one other lawyer from our office, Your Honor, but she won't be handling witnesses or anything. I mean, probably she'll be sitting behind us, but if you want her name, you want to introduce her, she will help with discovery.
Well, if it's apparent that she's part of the defense team, yeah, I should listen.
Okay.
let people know who it is. What's
Her name is Eleonora.
Eleanor or
Eleonora. Leonora.
Eleanor. Last name?
Lanzoni. Lanzone.
All right, so you're going to be here at 10 on Tuesday, and then we'll go down to the 9th floor, go to Department 102, and that's where we'll do the trial. Is there anything else we need? Oh, thank you. On objections, no speaking objections.
Okay.
You object, state the legal grounds, but no speaking. No speaking objections, I should say. Explaining why you think that the
Why it's
objection should be
hearsay.
overruled or sustained. Just state the reason, the legal objection, and I'll make a decision if you're overruled or sustained. Is there anything else we need to talk about, Mr. Priscilla?
Your Honor, I have the 2 reports that I was referring to from those witnesses that counsel addressed. I'm going to give them copies.
Well, we don't have them, that I just confirmed, so.
Okay, well, now you got it.
Yeah.
And why don't you say for the record what it is?
I will send him an electronic copy, but I do know we already turned them over. But now he has a paper duplicate copy.
All right. Anything, Mr. Lewin, anything?
No, thank you, Your Honor.
Mr. Tacopina, anything?
No, you aren't.
Ms. Kaplan, anything?
No, thank you.
All right, make sure your client knows to be here. I want him in this courtroom at 10 o'clock
Sure.
on Tuesday.
He'll be
And
here
he has to
going
be
forward.
here each and every day,
Of course.
anytime we're in session. And while the jury is deliberating, I want him here in the courthouse.
Of course, you are.
All right, if nobody else has anything, we'll see you on Tuesday.
Thank you very much.
Okay, you're welcome.
No.